So I want to give you an example of a person who came and saw me not long ago, who was a pedestrian who was struck by a motor vehicle. And the person said to me, "Greg, do I have a claim because I wasn't in the crosswalk when I got hit? In fact, I was jaywalking when this happened. And I recognize that I might have some partial responsibility for that. Does that mean that I cannot file and receive reasonable compensation for my injuries in this because I might be comparatively at fault?" And the answer is that it depends on the specific facts, but in general, Florida law recognizes comparative fault. So if you have partial responsibility and a jury ultimately determines that you've perhaps failed to use reasonable care under the circumstances, they may apportion a degree of liability or a percentage of fault to you. On the other hand, they may weigh that percentage of fault with the other side, with the vehicle, with the driver of the vehicle that struck you. And one of the things that we have in Florida is that the driver of a motor vehicle has a duty to exercise reasonable care to avoid striking pedestrians. So there may be a question about lighting. There may be a question about whether there was ample lighting, that the driver should have seen you. There may be a question as to whether or not that driver was distracted by something, perhaps a cell phone or something else that was involved. So by the mere fact that you may have been comparatively at fault in this pedestrian accident in which you were struck, that does not mean that you may not have a case to be able to pursue a claim against an at-fault driver that was also potentially comparatively at fault.